What's going on, everybody? This is Lady Luck Club. Thank you all so much for tuning in. You guys see the title of this video. Candace, Candace, what are you doing, Candace? Oh, I have some videos to play of Candace saying that she was not seeking a dismissal. Because liars gotta lie you. Candace, I tried to leave you 2 comments in your videos asking when were you going to file the legal response to this lawsuit. And as opposed to that, I've got some court information showing that your attorney is seeking, or no, has been granted an order to have the term limit, meaning the number of words you can use in some of these pleadings and documents, because judges don't want to read all that bullshit. Your attorney had to ask the court for permission to go past the extended term limit to be able to file a motion to dismiss. Didn't she say on Tucker Carlson that, you know what? I'm going to play the video. Before I do that, I want you all to give a huge, huge round of applause to the creator of this song, Minion with Opinion. I will have his YouTube channel link in the description of this video. He made this song called Bring That Ass Here, Boy. It just seems so befitting. Candace, why are you shying away from the lawsuit but talking about doing a season 2? How bad do you really want this to get for you? So I want you guys to hit that like button. I want this video to be shared with everyone, because what you cannot do unless you're tapped into some alternate reality is ignore or deny information in writing on the court docket. And if you don't believe me, you can always foyer the court. I hope someone does so that I can get the actual orders and the document in my hand or in my email, as a PDF file. But I want you all to please make sure you hit the like button. You subscribe to the Lady Luck Club, because we are growing. I wish this video, I hope it blows up. She can call me out and be mad at me for days about this. It's obviously what you and your attorney are wanting to happen, because Candace, your attorney asked the court to grant them permission to go over the term limit, the number of words they can use in filing. So yes, share this video, and all of the brainwashed diehard cult members, you can catch it here. I know how to handle trolls. One thing we don't do, I don't personally operate on conspiracy theory. And what we don't do here is go on some idea or belief without facts and evidence. So even if I give my opinion of something, it's because I can substantiate it with some documentation to show people why my opinion has been shaped and formed in the way it has. So share this video. I'm tagging Candace in this because you lied. And I want you all to subscribe to the Lady Luck Club. Consider becoming a member, because if you think this is something, imagine what we're doing in our members' live. The member-only live streams are lit. And we have a good time and let loose and talk about things that, I don't want to have brought on my main platform, because it's just going to drag it down and my analytics. So it's certain things that just everybody doesn't want to hear about, but there's certain things that people want to discuss, get off their chest, and release off their shoulders. And that's what the members only live is all about. And then, of course, ways to donate to the Lady Luck Club will be in the description as well. There's Cash App and Zelle. Any supers, memberships count. I typically have like a $25 goal for the live stream to help towards the expenses for creating this great content. And I just have to thank all of you for supporting me. But what really goes a long way is the engagement hitting that like button and sharing the video, and let's grow this platform. And I'm always willing to support other great content creators. So Menu with Opinion is one, and we're going to be utilizing Legal Eagle's video today, as well as Candace's own video. So let's get started. We have some information to discuss, and I will go over the product information. We're partnered with Dr. Squatch at the end, but I am so excited to share this because Candace told us that there was no way in the hottest part of hell she was going to have this dismissed, and for reasons, I guess she was just playing on that. Candace, you said it, girl. Oh, child. Candace said it. So I'm gonna play her video first. It's like a little short video, and then we're gonna get to Legal Eagle, where he has the clip of her on Tucker Carlson saying that there's just no possibility in heaven, on earth, or probably in hell that she's going to dismiss this lawsuit. Candace. Okay. So let's check out this video of her having all of the courage in the world. And then we'll get to Legal Eagle, and then we'll get to the court docket. Let's go.
I think you're sick. I think you're disgusting. And I am fully prepared to take on this battle. You are officially a very goofy man, Brigitte. But I got to give it to you. You've definitely got balls. If you need any more evidence that Brigitte Macron is definitely a man, it is just what is happening right now. The idea that you would file this lawsuit is all of the proof that you need. Okay. I have been in communication with their lawyers, or via our lawyers, like their lawyers and my lawyers have been speaking, phone calls, emails since January.
That's how lawsuits work, Candace. And you are not a stranger to this because you lost a case dealing with Lead Stories LLC, Gannett Satellite Information Network LLC. You tried to appeal it, and the appellate court upheld the ruling of the lower court for it to be dismissed because of failure to state a claim. See, I have the court documents. You can't bend and manipulate reality for everyone, Candace. You have children. When is this ridiculous shit going to end? Season 2, Candace. Chapel.
They did not send us a copy of a lawsuit. They did not give my lawyer a heads up that they were filing a lawsuit, but they did instead opt to get this lawsuit ahead of time. The Financial Times, the New York Times, CBS News. What does that tell you? Speaking, phone calls, emails since January. They did not send us a copy of a lawsuit. They did not give my lawyer a heads up that they were filing a lawsuit, but they did
not quite sure. Hold on.
Instead opt to give this lawsuit ahead of time to the Financial Times, the New York Times, CBS News. What does that tell you? It's a PR strategy. They don't care if they...
Oh, 1 second. Hold on. Let me go back a little bit.
They did instead opt to give this lawsuit ahead of time to the Financial Times, the New York Times, CBS News.
She said they didn't give her a copy.
Send us a copy of a lawsuit. They did not give my lawyer a heads up that they were filing a lawsuit, but they did instead opt to give this lawsuit ahead of time to the Financial Times, the New York Times, CBS News. What does that tell you? It's a PR strategy. They don't care if they win. This is about running it through the press. I found out with all of you. I found out with the world. I found out from the Financial Times that I was being sued by the first couple of France. Not normal, guys. The Financial Times reported that the lawsuit also says that their filing includes a description of the circumstances in which they met. The president was a 15-year-old student at Jesuit high school in Amiens when he first encountered Brigitte, then a 39-year-old married teacher with 3 children. So much of that is not true. Again, they're trying to say he's 15, he's 14. According to the filings, they, quote, formed a...
Okay, but what does that have to do with you purporting your belief and theory to be a fact about her being born a man? What does that have to do with that? Yeah, we have to separate the concept and idea of her being born a man versus some aspect of grooming and the age gap when they met. No one is disputing the fact that it's just disgusting to hear. But at the end of the day, that has nothing to do with her being born a man, which is something you would have to prove with facts. And you guys could tell she was just livid. She's just going off. She's not thinking about anything she said. And she's too busy just going on. She's just snapping all over the place.
deeper intellectual connection when she directed a production of the 1971 Milan Kundera play, Jack and His Master, in which Macron played the lead role. And later, the two began meeting regularly to collaborate on another play. Their relationship, quote, remained within the bounds of the law, the filings say. But when the teenager's parents found out about his, quote, strong feelings for his teacher, they moved him to a different school. Before he left, he told her, whatever you do, I will marry you. Dude, you're such a creep. Like the fact that you're stating this as a defense, and you're not even telling the truth here, okay? Because you can't ignore the facts of how old he was when he was in that play. You just can't. So happy to go through this in court. But do you realize how creepy you are? How creepy this sounds? His parents then...
So let me be clear on this. If that's all that the lawsuit was about, the age he was when they first met, or even the age he was when they first started dating, that's one thing. That could probably be a matter of debate. I don't think they ever lied about the age gap. They wouldn't double down and put it in a court document, even with the optics looking really, really bad, Emmanuel Macron. It looks bad. It sounds bad either way. And this is coming from a mother who has two boys, one of which is going on 17, which would have been 2 years older than the age you were when you allegedly met Brigitte. I don't even need to know how old he was when they started dating, because I would find it appalling as it is for there to be any hint of a romantic anything between a 14 or 15-year-old child versus a teacher, a grown woman who was married with 3 children at the time. So it's understandable to be livid about that. But whether they said 14 or 15, that is something that they can attest to, because he knows how old he was when he first met. And here's the second part of that. Based on the laws of France, the consenting age is 15. So let's just say, for the sake of argument, that he said, I was 15 when he was in actuality 14. What is it that you expect the courts to do about that? What do you expect the courts to do about that right now? In the United States of America, by the way. This lawsuit has been filed in the U.S. court. In a U.S. court where our laws and our Constitution, both federal and state law, would apply in that matter. Not the law of France. So what do you think the court is going to do about something that happened over, 30 years ago? I don't know how old Emmanuel Macron is right now, and I really don't need to know. Because that's not the actual statement of claim. That's not what you're saying. You all lied about that. I called you out, and now you're suing me about his age. No, they're suing you because of the defamation regarding the first lady of France being born a man, and you're calling that a fact. And her attorneys haven't told her shit, I guess. And you need to fire them once they get through filing this motion to dismiss.
Took him away because I'm disgusting, right? Because I'm a creep. Because I had power over this student and tried to seduce him, not because I looked like Claudia Schiffer.
Ooh, you can't make this up.
Because I'm just like a creepy old man. Like, that's what happened here. And you stating this is like, oh, it's so disgusting. We're not going to shut up. You're not going to bully us. The discovery alone is going to be out of this world.
Really?
We would be required to depose President Donald Trump.
No, you won't.
Same day that you were here, I got the phone call. So what's going on? Which, by the way, he acknowledges that the phone call happened.
No. You're not required to depose him. He is not required to even agree to be deposed in your civil proceeding where he's not listed as a party to the case. And you can't say he was a witness to you. I mean, you didn't even want to accept the photos. So what would he be, deposed over? It would only have to be from the stance of a witness. And what exactly did he witness that you feel would be vital or pertinent to your case? Let's just move on.
In this filing, you've met your match. I will see you in court.
Great. So
Owens is already using.
I'm gonna go back. Let me just set up the video here and just kind of let you guys know when it comes down to court, things aren't as straightforward in civil proceedings as one may think. Some people learn that the easy way. Some people learn that the hard way. I got to be honest. I had to learn that a little bit of the hard way, not too much, because I understand the odds of what I'm working with, especially when the burden in a civil procedure is a preponderance of the evidence. That means you just need to be 51% convincing. Is it more likely than not? So whatever discovery she thought she was going to get, or deposition even, no. So let me go to Legal Eagle, and I did a video kind of covering and I'm gonna rewind it back a little bit, but I did a video covering his response to this and what he said about this lawsuit. He read it. He's an actual bar licensed attorney, and he went through it. He did a video on it and covered it, and then I reacted to that because, you know, I think it's important to get the perspective of an actual attorney. I can say proudly I'm not an attorney. I don't even want to go to law school, and if you find me dead on a law school campus, it's a joke that someone's playing on me and Jesus. It's a cruel joke. So I have no intentions of going to law school, but it doesn't mean that I should not be, you know, educated and knowledgeable of, you know, laws and certain proceedings and how they're conducted in court. Court rules. There's a thing called federal rules of civil procedure. I mean, the law and those rules kind of dictate how the case should go on, but you know, you got to add in the fact that judges have, you know, discretion, you know, the discretionary powers of the court and the bench. You know, the judge could determine, you know, hey, I'm going to allow and accept the exhibit of her birth announcement, the first lady birth announcement, and some photos to be sufficient evidence to rule and conclude that they've met their burden. The judge is not going to order. Judge Rennie, I think, is her the judge over the case. Judge Rennie is not going to just sit here and order anyone, including the first lady of another country, to give up DNA, to give up blood to you. And Candace, you won't even tell your platform that. What are the odds of me getting blood? It's like less than 1%. She could have said that and just ran over that, at least put it out there. And she has such a heavy base, they believe everything she says. They're not researching anything, but whatever. And it's misleading. And you had enough evidence presented to you that will be sufficient in the court of law to stop defaming this woman when it comes to her being born a man. Because that is not a matter of your opinion. That is a matter of fact and science and biology and human anatomy. And that's what they're really upset about. You're taking away her motherhood. Oh my God, come on, girl. Then we're going to get to the day at the top of it all. French. So let's check out Legal Eagle. And like I said, I've done a reaction video to this in the past. He's very smart, very brilliant. He's been on YouTube for a while. I wish to God I could hire him as an attorney, you know, and he's just handsome as ever. All right. Thumbs up to Legal Eagle. Make sure you guys check out his channel. Let's get to it.
An opportunity to fundraise.
Will Wallace writes, I'm also a sponsor. I'm going to sponsor you right into winning this case. We have to let the world know not to mess with Americans, especially our women and children. Thank you guys. And we have seen this, there's definitely an uptick in donations.
And frankly, I would love to find out who's representing her in this suit, because she is doing everything you don't want a client to do, starting with doing a 2-hour interview with Tucker Carlson. In the relevant portion of this interview, she says that she's not going to dismiss the suit, or not going to even try to dismiss the suit, to try to get discovery against the Macrons.
So you're not going to try to have the case dismissed?
I certainly do not want to have the case dismissed.
Amazing.
Yeah,
I've never
so
heard that
we're having these
guys, I just
discussions.
want to linger on this for a moment, having been around a lot of lawsuits.
Yeah, I want to linger on this interview. Hold on.
She says
Let me
that
put the
she's
caption
not
on.
going to dismiss this suit, or not going to even try to dismiss this suit, to try to get discovery against the Macrons.
So you're not going to try to have the case dismissed?
I certainly do not want to have the case dismissed.
Amazing.
Yeah,
I've never
so
heard that
we're having these
You guys,
discussions.
I
And
just
then,
wanna
hold on,
linger
let me
on
go
this for a
back
moment.
one more time. I just got to get it
Using her
in.
in the suit, because she is doing everything you don't
One more
want a
time,
client
y'all.
to do, starting with doing a 2-hour interview with Tucker Carlson. In the relevant portion of this interview, she says that she's not going to dismiss the suit, or not going to even try to dismiss the suit, to try to get discovery against the Macrons.
So you're not going to try to have the case dismissed?
I certainly do not want to have the case dismissed.
Amazing.
I certainly do not want to have the case dismissed. Let's mark those words, shall we? Let's finish this little segment up.
Yeah,
I've
and
never
so
heard
we're
that
having
before.
these
You guys, I
discussions.
just want to linger on this for a moment, having been around a lot of lawsuits.
Okay.
I've never heard anybody sued,
Linger.
particularly they're spending a lot of money on this because Tom Clare and his wife have big expenses, and I think they charge a lot.
You think?
I've never heard anybody say,
Tucker. You think they charge a lot? Most attorneys charge a lot, especially if they have their own firm and they are practicing independent. They're not, some public defender or anything or on someone else's payroll here. Of course they charge a lot. How much do you think her attorneys are charging her? She gave out an estimate of what, $5 million? You all correct me in the comment section if I'm wrong and give me the video link that states otherwise, unless she's just throwing out random numbers here. But I do know that she has said that the attorneys representing her, the total amount would come up to like $5 million. And she's already sitting here talking about this is going to impoverish me and all of this, blah, blah, blah. Girl, you are worth $220 million. And if the estimate you received for $5 million was to cover the entire case from start to finish, I think getting away a little easy here. Don't make it seem like you don't have the money to pay him when you're worth $220 million. You better sell one of them properties you got.
I don't want a well-funded case against me to be dismissed.
Well-funded.
And that's one of those things that you say that's like, I'm going to take this all the way to the Supreme Court.
So, yeah, you take it all the way to the Supreme Court, it'll get laughed at in the Supreme Court. Candace, are you ready for the day at the top of it all? Are y'all ready for the day at the top of it all? As a matter of fact, I'm going to make the snippet of this docket my thumbnail because you just can't make this stuff up. Candace, I have the court docket. I have it right here, Candace. Court docket, case ID number N as in Nancy 25C-07-194. And yes, I will gladly put the link to this page from courtconnect.courts.delaware.gov in the description of this video, because you don't have to take my word for it. Here in this reality on earth, I know what I'm reading. This is too good. So Emmanuel Macron versus Candace Owens et al. The filing date was back on July 23rd. Defamation. It was a new case. You guys see the petitioner being Emmanuel Macron and his spouse, his wife, Brigitte Macron, and her attorney, their attorney, Brian Farnan, Michael Farnan. And then you have the defendant, Candace Owens LLC, Georgetown Inc. And the original judge assigned to the case was Judge Scott Jr., but it was reassigned to Judge Sheldon K. Rennie. So the Newcastle County Sheriff were the ones that provided the service, meaning they, tried to originally serve her with the lawsuit. But she said that it went to an address that was connected to something dealing with returns of merchandise in that same Tucker Carlson interview. I'm not going to play it because I'm not trying to go that far into that interview. But she said that it went to an address that we barely check. It's something, related to something along the lines of her using that P.O. box or that address for like return merchandise. So you can't say that they did not tell you, as she said in the first video, they didn't tell me they were intending on suing and this, that, and the third, but they tried to serve you from Newcastle County Sheriff, Candace. And if you don't believe me, let's keep scrolling. Keep scrolling. Let's keep scrolling. So, of course, there's a little history with Judge Rennie as well, because he oversaw the case that Candace filed in the Superior Court of the state of Delaware against Lead Stories LLC, Gannett Satellite Information Network. And this is back on 2021. Sorry, 2021. She filed a lawsuit. And that same judge was assigned the case. Yep. And you can check the court docket. I'll give you all the case number. As a matter of fact, let me show it right quick. This is just very quickly so you guys can see I'm not making this up because it's just too stupid to make up. So this was back on October 28, 2021 in the Supreme Court of the state of Delaware. And you see here the case number, S is in Sam. This is a CA number. I'm sorry. The number for the case looks like 2532021, but because this was an appeal, the CA number for the Court of Appeal is S is in Sam 20 C is in cat dash 10 dash 016 C is in cat, A is in apple, K is in kite. And then you guys can see here, she was the petitioner or the plaintiff in this matter. The defendants, of course, Lead Stories LLC, and I'm just gonna say GSIN Network, GSIN LLC, just to keep it short. And I want you to go down to the bottom. I want to go down to the bottom because that's what really matters in this. And this is just to show a history. I might go ahead and do a deep dive on this particular lawsuit, but this shows a history, of the way she handles these matters. I don't know if she's getting advice from she has an attorney. It's just like, why are you doing this? Sometimes it's okay as attorneys to tell your client, like, listen, I'm the judge, I'm the attorney, I went to law school. I know what the judge is going to want. I know what they're going to look for in a complaint. So the conclusion was the arguments raised in the opening brief lack merit. The Superior Court correctly concluded. Now, this is the appellate court now, but the Superior Court correctly concluded that Owens' claims of unfair competition and tortious interference against defendants and her claim of defamation against Lead Stories based on their fact-checking review of her Facebook post failed to state a claim. Here it is, y'all. Failed to state a claim under Rule 12, B as in boy, 6. The Superior Court's grant of dismissal from the defendants was therefore correct and should be affirmed. This was the ruling from the appellate decision. They upheld the ruling of the Superior Court. They upheld it. It says right here, this is based on the defendant's motion to dismiss due to failure to state a claim. It lacked merit. It lacked a lot of things. The judge, the court here, you see this here. The Superior Court grant of dismissal was therefore correct and should be affirmed. So when she filed this petition, they filed a response they filed a motion to dismiss, rather. And then they gave a whole outline as to why it should be dismissed. Now I want you all to see this formatting. Even for an appellate filing, you have to have certain formats for these court documents according to the Federal Rule of Civil Procedure. And you have to have certain components and elements included. So you have this, initial cover for the brief itself. Then you got the table of contents, and you see it broken down, the actual filing broken down into, sections, because judges don't like reading all this stuff. They really don't. But what you see here is table of authorities. This is vital. Candace, I hope you're paying attention. This is crucial and vital for two reasons. It's giving the court the understanding of applicable case law and how similar issues, such as the matter being heard, have been ruled on in previous cases. So it builds what's called precedence. And you get this, consistent interpretation of law and the type of evidence that would be, proper to help justify the claim and prove the statement of claim in that matter. So all of that can be established in case law. That's what this is. It's case law. So you have all of these court cases cited here. And I just don't understand. Did her attorney not read any of these? So they used, let me go back up. to the first, his page, the first page, page 4, page 5, that's 2, page 6, 3. And then you guys see the rules. This is federal civil procedure, court rules that we have to, abide by with civil proceedings. 3 pages of cases, prior rulings. So I just want to point that out so that you guys can understand now. She tried this stunt in 2021 and was shut down twice for failure to state a claim. Because you just can't make this up. And you talk about the Macrones filing a lawsuit to shut you up. The defendants have the right, and most times it's standard. It's very standard and typical for the defendants in a civil proceeding, to file a motion to dismiss. You might see it in some criminal matters too. First thing they'll ask is, listen, we're going to go ahead and motion the court to dismiss this for all these reasons. And then if the judge grants the petition, the motion to dismiss, then that's it. Of course, you have the right to file an appeal. It's part of our rights we have in the United States of America. But then when the higher level court that heard or at least read the filing for the motion to dismiss, what they're looking for is, okay, was there some sort of misinterpretation of law? Was there some sort of finding of fact that was omitted? Something technical, or based on the legal aspects of understanding and interpreting the law itself. They had adequate case law cited. And the judge read it and had to agree. This needs to be dismissed. And it was affirmed and upheld. And she, Candace is just, what kind of delusion are you got? You have 4.5 million supporters on your platform. I mean, the delusion on this is just mind-blowing to me. So I can only hope that people will kind of do a little bit more digging, do their homework. This is one case where, she's the petitioner in this, and she wants to talk about frivolous filings. But yet you did the same thing, Candace. In this case, you filed this petition. Even if the court doesn't say that it's frivolous flat out, right? The fact that it was dismissed, you appealed it, and then it was affirmed and correct that the dismissal stands. That speaks volume. It speaks volume. So now here we are in the year of our Lord 2025, where you have the French president and first lady suing the hell out of you, Candace. And you're crying about it on your platform. You're having a tantrum on your YouTube channel because they sued you. It's called accountability. You don't get to act with impunity and not think that this is not going to come back and bite you in the ass. So I want to make sure I highlight once again her attorneys, Catherine Mowry, Chad Chandler, Blake Roybacher. I hope I'm saying that right. I'm not trying to butcher the name here. So when we go down through this case docket, if they have the attorney listed, then you'll know her attorneys representing her. She has to agree to the attorney saying, I think we should file a motion to dismiss. Now, has she been adamant and said, nope, not doing it? At the very least, the attorney say, okay, I guess we're doing this. Bad idea, but whatever. Let's go ahead. Or she could just fire that attorney and get another one that will go through it. But the fact that we have now in the court docket some entries that have been entered, and I'm going to read it. We're going to go down first. I just want to make sure we go over the initial docket entries here. Filing of the defamation docketed July 24, 25. The initial complaint. You guys can see here the initial complaint date docketed 7/24/25. Complaint case info statement for defendants Candace Owens LLC and Georgetown Inc. Summons for defendants. Y'all see this here? Summons for defendants Candace Owens LLC and Georgetown Inc. And then you have Here next, let me go down. On 7/24/25, writ issued. Writ issued on date docketed 7/25/25. 2 writs issued for Newcastle County Sheriff. Parcels picked up and took Newcastle service to Sheriff of Newcastle County. So they're the ones that originally tried to serve the summons, the subpoena to her. I mean the lawsuit. My bad. The lawsuit itself. They're calling it summons. I'm gonna go with that. So, and you have see here, and 1 writ issue for 3104 on 7/23/25. Check number, and it was $45 to have that service done. And then you guys see here, writ return generic. Docketed 7/26/25. Registered agent served July 23rd, 25 at 10:51 a.m. That's what this is. Georgetown Inc. at 1013 Center Road, Suite 403S, Wilmington, Delaware, 19805. The writ that they tried to serve at this address, Candace, was returned. How do you lie that bad in saying you were never informed or aware that they had filed a lawsuit? They tried to serve you. It's not their fault that you don't check your mail at this address. That's not the fault of the petitioner or the court. This is you put this address down as far as, doing business and things of that nature. You should have like a legal team, someone with compliance, some level of a legal compliance department that can give you counsel as these things like this come up. I mean, you have 4.5 million subs on YouTube alone. Don't you think that you're going to be easily targeted for a lawsuit? Especially with the things that you say. You will want to have a valid address on file, not a P.O. box. A valid address on file. In the event you are sued, you can receive the summons. It was returned. And you lied in your video that I played earlier saying they didn't even tell us. This is them telling you. And that's it. This is their way of telling you that they're suing you by serving you a summons. You can't make this shit up. Yeah, here you got, it was 2 writs that was written now. So here's the second one. This is from Newcastle County Sheriff yet again. 7/25. Date docketed 7/26. Registered agent served on 7/23, 10:51. And then you have it yet again here. The address, Candace Owens LLC at 1013 Center Road, Suite 403S. I mean, they tried. You didn't get it. Then you have a letter. So here's the letter docketed. The entry on this, July 29/25. Letter to counsel on 7/25/25, advising that this matter has been reassigned to the Honorable Sheldon K. Rennie. So the original judge was taken off the case, and this was reassigned to Sheldon Rennie, who has prior experience with Candace from the case against the Lead Stories LLC that she lost in lower court and in superior court. So she lost twice. Oh my God. It's simply a matter of you failing to state a claim. So when you're the petitioner, Candace, you still can't get it right. All this money you're worth, and you can't make sure that a complaint is filed and you adequately state a claim on it. Oh, and an attorney did that for you, because I know she didn't type that up. She don't know what she's doing here. So after the judge was reassigned, ladies and gentlemen, then there was an affidavit of service docketed on August 1, 2025. Affidavit of service for Candace Owens, served on July 23rd, 2025. Stipulation, you all see here, Catherine L. Mowry, that is her attorney. Stipulation date docketed August 14, 2025. So you have that right here. August 14, 25, stipulation and proposed order. Here it is. for extending time to respond to complaint through and including September 11, 25. So here's the first sign something's about to go and shift to the left. I did a separate video reporting this information here. As of August 12, when this entry was done with the court, they had already stipulated and proposed an orders extending time to respond to the complaint. So they were given until 9/11 to file a response to it. You guys see here, Sheldon K. Rennie is the judge. So that order, the petitioner request was granted. So they were given additional time to respond to the complaint. Now we get to the juicy part. This was on August 25. Catherine L. Mowry. This is her attorney. I want to make sure I stay consistent with saying this because this isn't something she did on her own or something that the petitioner had someone else do. No, this is coming from Candace Owens' attorney, Catherine L. Mowry. This is a letter for judicial review. Y'all ready? Letter for judicial review, date docketed August 27, 25. Letter to the Honorable Sheldon R. Rennie from Catherine L. Mowry, Esquire, on behalf of defendants Candace Owens LLC, and George Tom Inc., respectfully requesting an extension of page. Listen to this. Extension. I'm gonna make sure I highlight this right. Extension of page and word limits on briefing for a motion to dismiss. I know this video is a little long. I don't care. Just watch the whole thing. Oh my God, Candace, you are the gift that keeps on giving. This video needs to go viral. I don't care if she cussed me out. Because what you cannot do, Candace, is deny this stuff that I'm reading with my own 2 eyes plus pair of glasses on. Yeah. This is what is on the docket entry for the court. This is not my website. It's not a fake website. And there's nothing fake about this information because any one of you Candace supporters, I mean, diehard Candace supporters that just won't believe that, we're breathing air here on earth. Whatever. You want to be tapped into the reality, have fun there. But for the rest of us, we can accept what is on the court's website. But if you're diehard and you still don't believe it, do a FOIA request from the court. Get the actual letter. Get these orders. Get the actual documents and then upload it. And while you're at it, email me at LadyLuckClubLLC@yahoo.com. I would love to actually see this letter for judicial review. This is a docket entry. So a lot of times it just kind of sums up what happened and mostly speaks to the ruling and the request. So they requested an extension of page and word limits on briefing for a motion to dismiss. Okay, get the document from the court. Do a FOIA and post it up for everybody to see. Because PACER doesn't include, Superior Court. It's federal matters. But whatever. I would love to see the actual documents. Exhibit A, 2 letter to the Honorable Sheldon R. Rennie from Catherine L. Mowry Esquire on behalf of defendants Candace Owens LLC, and George Tom Inc., respectfully requesting an extension of page and word limits on briefing for a motion to dismiss. And then you have, and I'm reading the exhibit here. So that was Exhibit A, the letter. Exhibit B, 2 letter. Exhibit A to the letter. I'm sorry. And then you have Exhibit B to the letter that supports the motion itself. 2 letter to the Honorable Judge Rennie from Catherine L. Mowry on behalf of defendants Candace Owens LLC, George Tom Inc., respectfully requesting an extension of page and word limits on briefing for a motion to dismiss, plus the proposed order increasing word limits for motion to dismiss, briefs accepted. And then you have by in the transaction ID number. So your attorney, Candace, will not ever file a letter to a court if they are honorable and they believe in maintaining good status with the Delaware State bar. Every state has a bar association. I highly doubt they're willing to stake their credibility and reputation for the sake of your ego and your pride. So they would not waste the court's time with filing this letter for judicial review. And if you, Candace Owens, did not agree to this as their client, they would not have done it. Because they know at any given time, she could just fire our asses and get another attorney that is willing to do all of that. You had to agree to this, Candace. They're representing you in this matter. So unless they do some sneaky stuff, typically they're speaking for you. And you agree for this letter for judicial review to be submitted to the court. I just want the whole attention to be brought on the motion to dismiss part. Who, man, I am here for this. So August 26th, order from Judge Rennie. Order date docketed August 27, 2025. Order signed by Judge Rennie. So ordered, proposed order increasing word limits for motion to dismiss briefs. Opening 12,000 words, answering brief 12,000 words, reply 9,500 words. The reason why they have to do this is because certain documents do have term limits. They have a limit on the words itself, because it prevents it from being overly lengthy and too much of a burden on the court and the judge to read. And if you have a case and you know how to get straight to the point, you really should not have to write a 5,000 page novel or do an 8-part series. Again, you're trying to do season 2, Candace. But this is how you're responding to this lawsuit, though, that you said you will not be filing a motion to dismiss. Wow. Wow, Candace. So each of these documents they listed here are separate documents. So the motion to dismiss briefs has 12,000 words. The answering brief, 12,000. The reply, 9,500. Okay? Because what's going to happen is once they file the motion, then really with the letter, the petitioner, the plaintiff's attorneys have the right to respond to it. So let's move on down. Here's August 26th. So noted, meaning the court takes the observation. We're notating it in the docket. So noted, date docketed August 27, 25. Order signed by Judge Rennie. Noted, letter to the Honorable Sheldon R. Rennie from Catherine Mowry, Candace's attorney, for the defendants listed, respectfully requesting an extension of page and word limits on briefing for a motion to dismiss. That has nothing to do with you wanting discovery. It is for a motion to dismiss, Candace. Come on now. Then you have August 26th, letter for judicial review from Brian E. Farnan, which is the attorney for Emmanuel and Brigitte Macron, right? Letter for judicial review, date docketed August 27, 25. Letter to the Honorable Sheldon K. Rennie from Brian E. Farnan regarding response to defendant's August 25th letter. So the defendants filed this letter for judicial review. An order was granted, and then the opposing party has the right to file a response. Yep. This is what makes these matters so lengthy, the back and forth with it. And because, we all have rights here in the United States of America, not just Candace Owens, to be able to respond to nonsense. Of course they did a response to the letter. They're probably wondering, okay, why do you need a term limit to be expanded to explain what? Other than you want this to be dismissed. You wanted this to be dismissed. I mean, you can debunk us all day. But Candace Owens said on Tucker Carlson's show, she will not dismiss this case. Oh man, I am loving this. And then you have August 26, 25. So noted. So this is the last docket entry where you have the letter, the response to that letter noted here on the docket, August 27, 25. Order signed by Judge Rennie. And this is the response to defendants August 25th. Let me highlight this. From Brennan E. Farnan regarding response to defendants August 25, 2025 letter accepted. Candace, you said you were not going to have this case dismissed. I really want these court documents. So if anybody has the ability to send me a copy of the order on this judicial review letter from Candace's attorney, if you can foyer that, because we all got the complaint, right? We were all waiting on her to file a legal response. But it seems like her response is coming in the form of a motion to dismiss. Now, let me be direct and clear on this. This is not surprising in any other situation because it's typically standard. It's just kind of a standard procedure to try to invalidate and, file a motion to dismiss, telling the court, listen, don't take this seriously. There's no merit to this. They're in the wrong jurisdiction. The venue is improper. For whatever reason, they will file a motion to dismiss as a defendant. So I'm not shocked that a defendant in the case decided to file the motion to dismiss. What is hypocritical about this is that Candace Owens said on Tucker Carlson's show that she would not have this case dismissed. That's the part that bothers me, and that's the lie that she told. But yet she didn't tell anyone that this was happening. She didn't tell anyone this is happening in the courts. You know why? Because she knows she doesn't have a case. She knows that. She knows, well, I can't believe they're trying to take free speech from me. I can't believe you're trying to take her motherhood from her. Candace, you're trying to snatch away the first lady of a whole nother country that you don't even live in. Her motherhood. You said she did not have those kids. She didn't give birth 3 times. That's what you said. And you lied, Candace. You lied about not having this dismissed. You're definitely trying to get this dismissed. I want to show you all something right quick. And she mentioned something with I wasn't aware that, that they were filing this, lawsuit against me or whatever, because reasons, legalese, she's not a lawyer. Okay. So intent to sue mandatory. In some jurisdictions, sending a letter of intent to sue is a mandatory step before filing a lawsuit. This requirement is often included in legal agreements or is a procedural step mandated by state law. And then they gave an example in California. I don't know, every state doesn't do this, but there are some states that, and depending on the matter, depending on the type of case we're talking about here, you have to send an intent to sue. But it might not be automatically required in every state, in every court. See, that's the thing, Candace. They tried to serve you twice, and that was good enough. So you you told on yourself when you said, well, it went to an address that we can have like paraphernalia and t-shirts go back and get returned. Yeah. At what point do you learn how to shut up? Because it's going to hurt you in your case. But you know what? Keep giving content creators like myself something to talk about, because I'm very thorough. I'm good at this. This is what I do. I research information. And when there's a matter of legality involved, your best bet is to go on the court's website to see what is on the docket, to see what has been filed, to see the entries, and to see what's going on in these hearings or conferences or whatever is happening in the court. Because that information is indisputable. I don't have to create a theory against Candace Owens. I can just pull up the court docket. That's all I got for today, you guys. Thank you so much for tuning in. Let me tell you something. This 55-minute video is worth every second. And I want you guys to make sure you check out the description below in the video for the products tag for Dr. Squatch, the soap, the deodorants, the toiletries for your young men to smell good, feel good, and clean, and you know, have that confidence that they're not walking around looking like Umar Johnson. So thank you all again for tuning in. Hit that like button, subscribe to the Lady Luck Club, because this is exactly what my content is all about. It is showing the facts. And then if the brainwashed people who are just gone and lost in space want to continue to just hang on every word from Candace Owens, let them. But what they cannot deny is what we're reading in the courts. And if any of you want to challenge me on what I just read, do a FOIA request and get the actual documents. Email it to me at LadyLuckClubLLC@yahoo.com. All right, y'all. Thank you so much. You guys have a good evening. And until the next one, Lady Luck Club out.